In 1966, the Lord Chancellor issued a practice statement announcing the rule to London Tramways and London Council 1898. Why? Because of decisions such as DPP and Smith. Because DPP and Smith was not the only wrong decision that was sitting on the law books. It had become clear that this restriction that the House of Lords had upon itself, being that it was unable to overrule any of its previous decisions, could create problems in the legal system. So the practice statement told us that judges in the House of Lords would from then be permitted to depart from their previous decisions. Now, today we don't have the House of Lords, we have the Supreme Court, but this practice statement is applicable to the Supreme Court. So the Supreme Court can depart from their previous decisions as well. The practice statement said adherence to precedent may lead to injustice in a particular case. So that's one of the reasons why they wanted to depart from what they had said in London Street Tramways. The practice statement said adherence may also restrict the development of the law. And they said that from then on, their lordships would depart from previous decisions when it appears right to do so. So the Supreme Court today still does attempt to follow their previous decisions, but now they have the power to depart from previous decisions when it appears right to do so. So there is some more flexibility in the English legal system. The practice statement did also make clear that the change does not affect the use of precedent in other courts. So this practice statement was only applicable to the House of Lords, and now it is applicable to the Supreme Court. It was not applicable and is not applicable to the Court of Appeal and other courts in the hierarchy. Since the passing of the practice statement, there have been examples of the House of Lords and later on the Supreme Court overruling previously decided cases. And we're going to have a look at one example of this, and we're going to see just how powerful it is in terms of rectifying wrong decisions that were previously passed by the House of Lords. We're going to look at R&GNR 2003 and how R&GNR was used to overrule MPC and Caldwell from 1982. We'll start with MPC and Caldwell from 1982 because that is the older of the cases. So what happened in MPC and Caldwell 1982? Caldwell was employed by a hotel and he held a grudge against his employer. After consuming alcohol one night, he went to the hotel and he started a fire. The fire caused damage to the hotel and he was convicted of aggravated criminal damage under Section 1(2) of the Criminal Damage Act 1971. So at trial, he was convicted and he appealed. What did he appeal in relation to? He appealed in relation to the required level of recklessness for conviction under the Criminal Damage Act 1971. Now his argument was that he was drunk and so he had not given thought to the consequences of his actions. The House of Lords responded to him and this is what they said. They defined recklessness for the purposes of the Criminal Damage Act 1971 and they said a person is reckless as to whether property is destroyed or damaged where he does an act which in fact creates an obvious risk that property will be destroyed or damaged, which he did, and when he does the act, he either has not given any thought to the possibility of there being any such risk or has recognized that there was some risk involved and has nonetheless gone on to do it. Therefore, the House of Lords was saying to Caldwell, it doesn't matter that you hadn't given any thought to the possibility of there being any such risk, because for the purposes of the Criminal Damage Act 1971, that is irrelevant. You can still be found to be reckless when you do the act and you haven't given any thought to the possibility of there being any such risk. So his appeal was effectively dismissed. This was a House of Lords decision, so it was a binding precedent for all the courts below it. Was it a satisfactory decision? Was it good precedent? After Caldwell, it became clear that there were some issues with this precedent. And it was finally with R&GNR 2003 that the House of Lords had the opportunity to overrule Caldwell, because Caldwell, it was clear, had created quite a problematic situation, and we will see how problematic it was when we look at RNGNR. Now, with RNGNR 2003, we had two boys aged 11 and 12 as defendants. They went camping without their parents' permission. They found some old newspapers outside the co-op. They lit the newspapers with a lighter and then they threw them under a wheelie bin. They then left without putting out the fire. They assumed the fire would naturally burn out. But unfortunately, the burning newspapers set light to the wheelie bin and the fire spread to the co-op shop and caused over £1 million worth of damage. So these boys were taken to court and they were charged under the Criminal Damage Act 1971. What was the applicable precedent? Caldwell. They were convicted at trial. When their appeal reached the House of Lords quashed their conviction and they overruled MPC and Caldwell 1982. I wonder why. You see, in RNGNR 2003, the House of Lords told us that the appropriate test of recklessness for criminal damage is as follows. A person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971, they said, with respect to a circumstance when he is aware of a risk that it exists or will exist, a result when he is aware of that risk that it will occur, and it is, in the circumstances known to him, unreasonable to take the risk. This is a very different test of recklessness to that which was given to us in Caldwell. What's the difference? In Caldwell, we were told that it was not relevant whether or not the defendant was aware of the risk. But in RNGNR 2003, the House of Lords is telling us that recklessness means that you are aware of the risk and that the circumstances are known to you and you take unreasonable steps which lead to the damage. I wonder why the House of Lords overruled Caldwell and gave us such a different test of recklessness in RNGNR 2003. If we look at Lord Bingham's statement in the judgment, he was part of the panel in RNGNR 2003, we will see exactly why. Lord Bingham told us, it is not moral nor just to convict a defendant, least of all a child, on the strength of what someone else would have apprehended if the defendant himself had no such apprehension. Because Caldwell allowed the courts to convict a defendant on the strength of what someone else would have apprehended if the defendant himself had no such apprehension. Because Caldwell told us it doesn't matter that you hadn't thought about it. But after Caldwell, there were quite a few cases, including children who did not have the capacity to know of the risk and damage that would have occurred from recklessness or careless actions that they took. So Caldwell was quite a problem in the courts because of Caldwell, we had an 11 and 12-year-old boy that were convicted of trial when they really were not aware of the risk that they were taking. So in RNGNR, the House of Lords decided to use their power to overrule their previous decision, and they overruled Caldwell, giving us RNGNR 2003, which was in fact a fairer test of recklessness for the purposes of the Criminal Damage Act 1971.